We've passed a law. City Council and I passed a law that said, under the police powers, that said we want to protect our sole source aquifer in the first ward from any pollution. So we passed the law, and the plaintiffs in this case were claiming that we didn't have the right to do that because what we were really doing was circumventing 239M review, which means it has to go to the county planning department for review and say, okay, yeah, this is okay to do this. And so they're claiming that we only passed this law to circumvent that, and we're saying no, we have the absolute right to protect our environment and our sole source aquifer under police powers.
Okay. And so what transpired today? Can you talk about?
Well, these were very procedural arguments, but the fundamental issue here is the ability of the city of Binghamton to protect its citizens and its property and its water resources, and it's about home rule.
Right.
This lawsuit is filed by landowner association lawyers who stand to make millions, and they're very bothered by towns and cities being able to protect their citizens, and that's the fundamental problem here.
I would also say that the other motivation behind this suit was really to scare off other. We know a lot of people, a lot of town councils are getting pressure to pass bans or moratoriums, and I think this was a preemptive strike to convince smaller towns who would not have convince them, if you do this, you're going to have to, defend this in court. So I think this was really they decided we're going to take a position against this so we can scare other towns away from doing this, and I hope that hasn't happened. If the town thinks it's right to protect the resources and their property, they should have and their citizens convince them of that, then they should go ahead and do it.
Joe, can you talk about the motion to dismiss? What was that about?
Well, there are two problems with this lawsuit, or many problems with this lawsuit. One, they waited too long to file it. There's a clear statute of limitations that when you're challenging a municipality or an action by a municipality, you have to do it within 4 months. They were weeks beyond that. That's enough to dismiss the case right there. The other problem is that none of these petitioners met the standing requirements, and this gets very esoteric, but because there is a tendency to often challenge municipalities, particularly in environmental protection situations, the courts are very, very cautious about who can bring these matters and just tie the thing up forever and then thereby essentially gutting the law. And so none of these people met the legal standards to bring this case. Those are the two fundamental issues that were talked about today.
I mean, my understanding of a cause of action is that you need to have an injury.
Absolutely.
Right. And the injury in fact is exactly what the judge talked about, and he questioned him about that, and we hope that he takes that, obviously into strong consideration when he makes his decision.
And the case laws are clear that it has to be a certain type of injury, and it can't just be conjectural. When you look at this petition, it's all about may, could, maybe I want to lease. Well, they couldn't lease before. They have a lot of problems on standing, and the judge understands that, and we'll see what he rules.
Right.
So, and then they countered with what? They countered with a motion for summary judgment.
Right.
They actually filed a motion for summary judgment absolutely prematurely under New York practice rules, and before we even responded. And the law is absolutely clear that you can't file one of those motions until the issue is joined. What that means here is before we had a chance to answer. The motion has to be dismissed just on that. They tried to dance around that by clouding it up by saying, well, here you can do a motion to dismiss. This is a motion for summary judgment. It's very clearly premature, and I think the judge was so clear on that, I don't remember that we even had to address it. So.
Right.
Now, some of the people in the court were making a big issue about the fact that the judge was calling the prosecution Bob Wedleg. And
I don't think that means anything. I mean, he doesn't know these guys as well. They've never been before him until this motion. And Mr. Wedlake does a lot of work in Supreme Court. So I don't think, I really got the sense that this judge is, going to be very fair, that he does not like where it is. He wants to be solid on the law, and I think he made that very clear, and so we're hopeful for that whatever decision will be a fair decision.
It's always refreshing to come into a courtroom where a judge is as well prepared as he was today. He clearly had read every piece of paper that had come in before today. He's very conscientious about the law, very, very well prepared. That's as much as I think we can ask for here. And I don't think the fact that he's practiced in this town for several decades, and so has one of the petitioner's lawyers, I don't get the sense that that's going to change his decision here.
Thank you, Joe. Thank you, Matt.
Thank you.
Appreciate it.